In this lesson, we're going to go over our case brief for Louisville and Nashville Railroad Company v. Motley. This is a United States Supreme Court decision from 1908. If you want to follow along, simply visit studicata.com/case-briefs. And from there, you can just search Louisville and Nashville Railroad Company v. Motley. This case is going to pop up. You just click that and you can follow along. You'll be good to go if you want to work through this case brief with me. So just for some quick background before we jump into the facts here, this case centers on the subject matter jurisdiction of federal courts. So for this case, we just really want to understand at a broad level the difference between state and federal courts as it relates to subject matter jurisdiction. This is going to help us really understand the court's decision here in Louisville and Nashville Railroad Company v. Motley. So if we're thinking about jurisdiction at a very broad level, we understand in the United States, we have state courts and we have federal courts, each with their own jurisdiction. Okay, and typically when we're thinking about subject matter jurisdiction, we're thinking about the type of case that's before the court. We're really asking, is this the type of case that this court can hear and decide? And this is usually a pretty easy question when we're dealing with a state court. State courts can hear and decide almost any type of case that comes before them. There are some exceptions. If federal law precludes the state court from hearing a type of case, then okay, the state court can't hear those types of cases. This would be like admiralty, maritime, bankruptcy, copyright cases, patent cases. In those instances, federal law actually says, hey, state courts, you can't hear these cases. Outside of those, though, typically we say state courts have virtually unlimited subject matter jurisdiction. They can hear almost any type of case. So if you have, say you enter into a contract with your neighbor and the neighbor's going to mow your lawn and you're going to pay the neighbor $20 to mow the lawn, right? And say you give the neighbor $20, but he never mows your lawn. Well, you might want to sue him for breach of contract, which is a state law claim, right? Whatever state you're in is going to have jurisdiction, subject matter jurisdiction over that case. That's the type of case that a state court can hear. A little $20 breach of contract claim between two neighbors. This is something that a state court likely is going to have the authority to hear and decide. Now, if we think about a federal court, it's the total opposite, right? Federal courts have very limited subject matter jurisdiction. They don't have the authority to hear that type of case. A little $20 breach of contract claim between two citizens of the same state, two neighbors. This isn't the type of case that a federal court has the authority to decide. In fact, federal courts have very limited subject matter jurisdiction. There's very particular types of cases that federal courts can hear and decide. For our purposes, there's really only two types of cases that federal courts can hear and decide. Cases that arise under federal law, which is the subject of Louisville and Nashville Railroad Company v. Motley, and cases that involve diverse parties. Basically, if we have like a plaintiff from Texas suing a defendant from New York, we say, okay, those parties are diverse. And today, if the amount in controversy exceeds $75,000 and the parties are diverse, that's a type of case that a federal court can hear and decide. But we don't want to worry about diversity jurisdiction here. We're really only focused on federal question jurisdiction. When we're asking, is this the type of case a federal court can hear and decide? Here in Louisville and Nashville Railroad Company, we're saying, is this a federal question? Does this case arise under federal law? Basically, in a sufficient enough way for this federal court to have federal jurisdiction over the claim. Okay, I think though that's enough background. We can kind of just get into the facts here in Louisville and Nashville Railroad. By the way, if you want a full breakdown of federal question and diversity jurisdiction, we have a ton of videos on that and you can really get into the details. I just want to establish basically the big picture stuff here though, because it's going to help us with Louisville and Nashville Railroad Company. Basically, what I would understand coming into this case is for a federal court to have subject matter jurisdiction, we understand that this is very different than asking whether a state court has subject matter jurisdiction over a case. Just remember, state courts have virtually unlimited subject matter jurisdiction. You can hear almost any type of case. Federal court, total opposite. Very limited in the types of cases they can hear. And really, our big issue here in Louisville and Nashville Railroad Company then is simply going to be, is this the type of case that a federal court can hear and decide? Okay, with all of that in mind, let's get into the facts here. So here, the Motleys a married couple were injured in a train accident in Jefferson County, Kentucky on September 7, 1871. In response to the accident, the Louisville and Nashville Railroad Company granted the Motleys annual free passes for railroad transportation as part of a settlement agreement with the Motleys for the injuries they sustained. So pretty sweet deal for the Motleys. They get injured in this train accident, but they settle with the railroad company. And as a result of that settlement, they get these free annual passes so they can ride wherever they want for free on these railways. However, many years later, Congress passes the Hepburn Act, which took effect on January 1, 1907. Important to recognize, since Congress is passing the law, it's federal law. So the Hepburn Act is federal law. This federal law prohibited certain types of free rail passes. Consequently, after this law takes effect, the railroad discontinued the Motleys' free passes in 1907. In response, the Motleys filed a lawsuit in federal court seeking to enforce the settlement agreement for their annual free passes. The Motleys argued that the federal law did not apply to their passes, which were issued as part of a contract before the law was enacted. So here, the Motleys' claim is based on state contract law, but they're anticipating a defense based on federal law, the Hepburn Act. So they're filing their action in federal court. And so the primary legal issue in this case was whether the federal court had jurisdiction to hear the dispute. This goes all the way to the United States Supreme Court. Specifically, the question the United States Supreme Court is trying to decide was whether a suit that involves a federal law as a defense to a contract claim qualifies as a suit arising under the Constitution and laws of the United States, thereby granting federal courts jurisdiction. So here, the United States Supreme Court held that the federal courts did not have jurisdiction over the Motleys' claim. The court ruled that a lawsuit only arises under federal law, thus granting federal jurisdiction if the plaintiff's original cause of action is based on that federal law. The anticipation of a defense based on federal law is insufficient to establish federal jurisdiction. So again, the Supreme Court's trying to decide, is this the type of case that a federal court can hear and decide? They don't have diversity jurisdiction, so they're really focused on federal question jurisdiction. Is this a case that arises under federal law in such a way that it gives a federal court the authority to hear and decide it? And they say, no, this case doesn't really arise under federal law because it's a state law breach of contract claim. Basically, the railroad gave them free passes as part of a settlement contract. Later on down the line, this law gets passed, and the Motleys then get this settlement agreement in their opinion, right? The Motleys believe that this contract has been breached by the railway company when the free passes are taken away. So that's just a state law breach of contract claim. They're saying it doesn't matter that the Motleys are anticipating this defense based on federal law, the Hepburn Act. They're saying, look, that's ancillary. The main complaint here is a state law breach of contract claim. This is an ordinary garden variety state law breach of contract claim. There's this ancillary issue of a federal law that the Motleys are anticipating. The Motleys are anticipating that the railroad company is going to point to this federal law and use that as a defense. But that's not the question. The question the court is saying here is whether the lawsuit arises under federal law. And we get from this decision what we now call the well-pleaded complaint rule. Basically, the United States Supreme Court here, and in the jurisprudence that follows this case, what's basically being said, though, is we really need to just look within the four corners of the plaintiff's complaint itself. We need to look within the corners of that complaint and decide, has the plaintiff here alleged a claim that arises under federal law? We don't care what the defendant is doing. If the defendant raises a defense under federal law or not, if the defendant files a counterclaim that arises under federal law or not, We just don't really care what the defendant is doing in the analysis of whether a lawsuit arises under federal law in determining whether a federal court has federal question jurisdiction over a claim. We're only going to look at what the plaintiff is alleging. And here the court says, look, the Motleys are alleging a pure state law breach of contract claim. Doesn't matter that they're anticipating a defense that's based on federal law. So the federal court there does not have federal question jurisdiction over a state contract law. That does not arise under federal law. This is not the type of case that a federal court can hear and decide. That is Louisville and Nashville Railroad Company v. Motley. I encourage you to come and read the reasoning here, the in-depth discussion. There's a lot of great information to get more on this. The main takeaway, though, from Louisville and Nashville Railroad Company is the well-pleaded complaint rule. I tell law students all the time, when you're trying to decide whether a federal court has federal question jurisdiction over a case, you really want to put the blinders on, right? You want to find the four corners of the plaintiff's complaint and just look at the plaintiff's complaint. And you're trying to decide from the plaintiff's complaint, do we have issues of federal law? Do we have a claim that arises under federal law based on the plaintiff's complaint? We don't care what the defendant is doing. It's just not relevant in the analysis. And that really comes from Louisville and Nashville Railroad Company v. Motley. That's what establishes, or at least cements, this principle. And then, of course, over the next 100 years of jurisprudence, it gets even further cemented. We understand that counterclaims that arise under federal law raised by the defendant are also not considered. But for our purposes, Louisville and Nashville Railroad really establishes this concept of the well-pleaded complaint rule. Basically, we only consider the plaintiff's complaint, when we're trying to determine whether a court has federal question jurisdiction to hear and decide a case. That is Louisville and Nashville Railroad Company v. Motley, United States Supreme Court decision from 1908.